Okay, we're live now.
Perfect. All right. So we are now live. Welcome everyone to our presentation on Guardians in Housing Court. My name is Adriana. I work here at HCA. We are just asking that everyone stay muted during the presentation. We have Dinah Luck and Megan White here to give us a wonderful presentation, letting us know about Guardians in Housing Court, how that works. We are going to have them go through the presentation. We ask any questions to be put in the chat. The questions will be answered towards the end. There will be time for you to ask your questions. Um, like I said, we are live just so that you guys are aware of that. Um, and you guys are ready to start. The floor is yours.
Thank you. I'm Dinah Luck, and I'm a staff attorney at Mobilization for Justice, where I've been in the mental health law project for um, 16 years or so. And my colleague Meg.
Hey, excuse me. My name's Meg White. I'm a senior staff attorney at MFJ. I work in the housing practice. I've been at MFJ for 7 years. Before that, I worked at HRA's Office of Legal Affairs doing guardianship, Article 81 guardianship work. So we're excited to be here. I'm going to start sharing my screen. I have a presentation, and then we can get started. Oops. Okay.
Okay, so we're going to cover just very briefly some ethical issues on working with guardians that specifically apply to attorneys. I know a lot of people here are not attorneys, so we're not going to spend a lot of time on that. And then most of the training is going to be about Article 12, Guardians ad litem, which is the vast majority of the types of guardians that you see in housing court cases. And we're also going to talk some, though, about Article 81 guardians, which is like a full guardian, and you do definitely come across them in housing court sometimes as well. And so knowing the difference between the two and what it means if someone you're working with has a GAL or an Article 81 guardian is pretty important in terms of what the guardian can do and what the tenant can do. Ethics. Okay. So just briefly for the attorneys in the room, if when you're representing someone, you are supposed to take direction from them, and they control the outcome of the litigation. And so, if you have a client who you think might have diminished capacity, is struggling to make decisions, you're concerned that they may not be able to make decisions about the case, in that situation, but that they would not want you to try to get them a guardian. In that situation, there is a little bit of an exception in the ethical rules that say when a lawyer reasonably believes that the client has diminished capacity, um, is at risk of substantial physical, financial, or other harm unless action is taken and cannot adequately act in their own interest, the lawyer may take reasonably necessary protective action, which includes seeking the appointment of a guardian ad litem or a full guardian. So that is just something to keep in mind if you're an attorney and you're dealing with someone who you think may need a guardian. You are allowed to do that under the ethical rules, but not just in any situation. You have to have a basis to do that. And then the other issue that comes up for attorneys is terminating the attorney-client relationship. I'm not going to read out that rule, but before you can withdraw from a case, you do have to take into consideration if it would prejudice your client or if it would harm your client. So if you're in a position where you're considering withdrawing from a case because you're not able to communicate with your client or your client's not able to direct you in the litigation, again, just for ethical reasons, you have to take into consideration how that will affect your client in housing court and how it might prejudice them. And just wanted to mention those up front, since this training deals a lot with people's ability to make decisions about their housing and their housing case. So the next section, we're going to talk about GALs, guardians ad litem. And guardians ad litem, GALs, are appointed under CPLR section Article 12, which says that a person shall appear by his guardian ad litem if he is an infant, has no guardian of his property. Sorry, I'm going to skip to the part that's relevant in housing court. So the part that's relevant in housing court is if he is an adult incapable of adequately prosecuting or defending his rights. So that is a really vague standard. And, if you're looking at that and thinking, I don't know what that means, then you are not alone. It's vague, and there's really not a lot of clarification except for what judges have decided it means, but there's not another section of the law that says this is what we really mean here. So if someone is incapable of adequately prosecuting or defending their rights, the appointment of a GAL is mandatory, which means that, a lot of times, especially, housing court judges or landlord's attorneys will say, well, what's a GAL really going to do? This case is a loser. You can't really, a GAL can't really do anything. Like, if a person needs a GAL, they need a GAL. The question is not like, what will a GAL do or what purpose will this serve? And that's true even if the person is represented by counsel. So if you have a client or you're working with someone who has an attorney and may need a GAL, the fact that they have an attorney does not change that. And then what it means to be incapable of adequately protecting your rights, that can include someone who has a mental illness or dementia or some kind of developmental disability like Down syndrome that does not rise to the level of incompetence. So incompetence means that someone literally cannot make decisions. And we'll get into that more when we talk about Article 81s. So someone who needs a GAL might still be able to make decisions, but they struggle with it. They don't fully understand it. They just need a little help maybe. And it can be hard to know if someone you're working with has that level of diminished capacity. And so in order to find out if someone maybe needs a GAL, the best way to do that is to interview the person and keep in mind that if you ask someone yes or no questions, they might just, like if you say, do you understand this case? And someone says yes, that doesn't mean they understand the case, right? They may be embarrassed to admit they don't understand it. They may think they understand it. So you want to ask open-ended questions where the person has to explain to you what is happening. And so, ask them like, what kind of case is this? What is this case about? A lot of times you'll discover when you do that, you're dealing with, maybe an eviction case where the apartment isn't regulated and the person thinks it's about non-payment of rent. And so you have a conversation with them to see if they don't understand the case because it's legally complicated, or if they don't understand the case because they're not capable of understanding it. A big one is finding out if the person understands the consequences of the proceeding. So what will happen if you lose this case? Where will you go? Have you looked around for another apartment? Do you know how much apartments cost in your neighborhood? How would you pay a security deposit? There's all kinds of open-ended questions like that you can ask someone just to see where they are on the case and to see if they really have a grasp of what's going on. And then, asking them like questions about actions they're going to have to take. Can they come to court? Can they go to HRA? Can they clean out their apartment if it's a clutter case? Can they sign a lease? Can they recertify their Section 8? There are all kinds of practical things that might come up in a case that the person might need assistance with. And so if you go through that whole process and at the end of it, you feel like the person may need a GAL, then it may be appropriate to try to get one appointed. And the next section is about how you do that. I just want to take a quick pause. The only question in the chat is why they're called guardians. I have no idea. So sorry, Jennifer. Does anyone have a question before we move on to the next section? Okay. So in keeping with the vagueness of this law, there's not a lot of details about how a GAL can be appointed. So there are a lot of different ways. One way is the judge can just do it. So if a housing court judge has someone in their part who doesn't seem to understand what's going on, they can just appoint a GAL. They don't have to have an expert evaluate the person or have a hearing. They can just write up an order appointing a GAL. Anyone involved in the case can make a motion. So landlord's attorneys can make motions for GALs. I have almost never seen that happen. Technically, they have an ethical obligation to do that if they're litigating a case against someone who cannot defend themselves, but they generally do not do that. A friend of the court can do it, which means that if you're not representing someone, but you believe they need a GAL and you see that they're at risk, somebody comes into an intake and you're not a lawyer, you can't take their case, you can file a motion as a friend of the court, letting the judge know that you believe this person has diminished capacity and may need a GAL, and then the judge can appoint a GAL just based on your motion. Obviously, the tenant's own attorney can make a motion, and that goes back to the ethical rule that I mentioned. And so, just again, you have to act in accordance with your client's wishes and maintain a conventional relationship under the ethical rules. So if your client does not consent for you to move for a GAL, you can't do it unless you fall under the exception listed in the ethical rules. And when you're considering whether to move for a GAL for someone you represent or your office represents, I know there are a lot of people here who aren't lawyers, you need to think about whether there are other things you can do short of asking for a GAL that can take care of whatever issue it is that you see. So if, for example, your client is struggling to pay their rent and they have a mental illness, that doesn't necessarily mean that they need a GAL. They may just need to set up automatic bill pay because, they struggle to remember to mail out their rent every month. If they need a heavy duty cleaning and are not able to clean out their apartment on their own, you can refer them to Adult Protective Services, or if they have resources, you can hire a cleaner. So if there are other avenues you can go down to resolve an issue with someone who may have diminished capacity that is less restrictive than appointing a GAL, then you should consider those options, and you should take those options if you can. And then the final entity that can move for a GAL is APS, Adult Protective Services. And this is this is pretty common, especially, with pro se, with tenants who don't have attorneys. The court might refer someone to APS, the landlord might refer someone to APS. APS does an evaluation, decides what kind of services the person may need, and then one of those things might be to move for a GAL. And then, finally, just to talk about, the relationship that you have with the person that you're working with. So whether you're an attorney and you're working with your client, or, if you're an advocate, and you're working with someone, that comes to some sort of social services organization that you work with, one of the things you need to think about is, what will a GAL actually do for this person? And is that worth maybe risking the relationship that you have? So if you're working with someone who will get really upset if you move for a GAL, if it will undermine their trust in you, and make it difficult for you to work with them, then you have to balance that against what benefits you might get from a GAL. So I have certainly had clients before that, I believed technically qualified for a GAL, but the whatever I would gain from getting a GAL did not make up for what I would lose by losing the client's trust, and undermining my ability to work with them. But on the other hand, even if you don't want to move for a GAL, if you have a client who's really significantly disabled, you have to consider, down the road, how a judge might react if you get to the point of, for example, going to trial, and then you raise the issue of, oh, my client needs a GAL, then the judge might have some questions for you about why you didn't move for that before. Another thing that I think can be a benefit to having a GAL is, once a judge has decided someone needs a GAL, then the fact that they have some limitations is part of the record. Like, the judge has made that official determination. And so then, if you're going through a housing court case and your client misses a deadline or misses a court date, or in some other way their disability affects their ability to engage in the case, you can just point it out to the judge, like, this person has a GAL. You've made the decision already that this person has certain limitations. And that can help you get some more time if you need more time, to get a one shot or to prepare for a trial. So sometimes just having that official decision that someone needs a GAL can be really useful, especially if it's like a really challenging case and you think you're going to need some flexibility from a judge. So I see there are a couple of questions, so I'm going to go ahead and so does having a GAL in housing court trigger investigations from agencies like ACS? Would that be a risk to discuss with the client if they care for a minor? So I want to be careful about answering this question because I'm not an expert on ACS. I have asked a colleague of mine who works at one of the defender services doing ACS defense, and he said he's never heard of it affecting someone's, he's never heard of it triggering an investigation from an agency like ACS. But that's one person's opinion. I don't want, to give the impression that that's a definitive answer, but that's the best answer that I have. Meg, have you ever?
I believe that APS caseworkers, and this is, again, just a reminder, I worked there like over 7 years ago. I believe that APS caseworkers are mandated reporters. It doesn't necessarily mean that just because you have an open APS case that ACS will get involved. If there are allegations of like clutter, and there's a minor in the household, then I think there probably is a risk of ACS involvement. But I don't recall any instances in which APS being involved with someone triggered an ACS investigation, but that doesn't mean that it can't happen.
And then the next question is, what would the relationship between GALs and APS be like? What can they do for each other? Will they constantly communicate with each other, or would one hand the case off to the other? In my experience, they don't communicate with each other. And a lot of times when I have a client who has an APS case and a GAL, I end up being like the conduit through which information flows. So there are definitely some GALs who communicate regularly with APS, but I don't think it's common.
Yeah, I would agree with that. Unless like, I guess, like Dinah said, there are some GLs who do communicate with APS, especially if they feel that, and we'll get into this a little bit later with the Article 81 slides, but I think that there are situations where if a GAL really feels that they are not the least like amount of intervention needed to assist someone, that they really work with APS to get Article 81 guardians. But like, they don't have the magic power to get a one-shot deal approved quicker than anybody else in this Zoom meeting. So that's that's the information you're after, if only.
Yeah.
Go ahead, Dinah.
Yeah. So then the next question that comes up sometimes is, when can you move for a GAL? And the answer to that question is literally anytime. And I said a few minutes ago that it might be good to move for GAL early in the case if you see it going a certain way where you're going to want that on the record, that the person has, some sort of diminished capacity. But another like fact about mental illness and developmental disabilities and dementia is that a lot of times those, a person's ability to handle things changes. So you might be helping a tenant who is perfectly capable of understanding the case, litigating the case, directing you, getting a one shot. And then, under the stress of the case or having a trial coming up, or, just having eviction hanging over your head is a traumatic experience. Then, symptoms of a mental illness can exacerbate, and someone may become unable to adequately defend themselves. And so you absolutely can move for a GAL like the day of a trial, in the middle of a trial, after there's been a judgment, because people's capacity changes. I've had a case. I've had a couple of cases where I had to move for a GAL on the eve of trial, and of course the landlords flip out because they say it's a delay tactic. But when I had to do that, My clients were in very bad shape, and it's not surprising that having a trial that could end in your eviction would trigger some, stress affects all of us. So, it's been very clear sometimes how someone decompensates because of the stress of a trial coming up. Right. And so then to discuss a little bit more about incompetence, lack of capacity and competence, and the standard for a GAL. So the standard for a GAL is, again, whether the person's mental condition would impede their ability to assist in the defense of the case. And so it's different from, whether a person, sorry, we'll get into I don't want to get into the Article 81 stuff until later, but it's specific to the case. So ad litem means of the case. And so if you have a client who has a mental illness or various levels of diminished capacity, but they are able to understand the case, and they're able to direct you, and they're able to come to court or handle the case remotely, then they don't need a GAL. So I've had a client that I represented several times who has active delusions. Like every time I've ever interacted with him or represented him, he's had like persistent delusions, but he also understands his case better than I do because he's been living it. His relationship with his landlord is something that he has been living for 20 years through repeated litigation and repeated eviction cases. And so even though he very clearly had a mental illness and had very clearly had some serious symptoms, he did not need a GAL because he was absolutely able to understand his case and direct me and make decisions about what we were going to do. And it's important to keep that in mind because there's a lot of stigma around people with mental illness, paternalism, assumptions that they do not have the ability to make those decisions. And so any decision you make about, whether someone needs a GAL has to take into account that having a mental illness does not mean that you need a GAL or that you have diminished capacity. And I think, Meg?
Yep. All right.
Over to you.
All right. So now we're going to talk about like the duties and the powers of guardians ad litem, right? They've been appointed by the court. What exactly can they do? Should they be doing? So a guardian ad litem has a fiduciary duty to their ward. I'm just going to refer to the person who has the guardian from like throughout as the ward. That just means they have the legal responsibility to act solely in the best interest of that person. I will get to that, Adriana, definitely get to that. So they are also, yes, they are solely supposed to act in the interest of the tenant, mostly the tenant, right? Sometimes there are landlords that get GALs, but we're all tenant advocates here, so in the interest of the tenant, but also officers of the court, whether or not they're lawyers. So they also have the obligation to make a thorough, fair, and objective report to the court. Now, when I hear that, I think, how on earth could that possibly be? How on earth can you possibly do both, right? How on earth can you work solely in the interest of your ward, but also make a thorough and objective report to the court? And that's just something that's a little quirky in the law, right? Like, and so there are instances where perhaps a GAL may disclose something that is harmful to their ward's case, right? You think about a clutter case. GALs often make reports to the court that include the extent of clutter, where a landlord might not know that, right? They might understand that there's clutter in an apartment, but they don't understand the extent to which, it has progressed. It's like nuisance cases, right? Like there's just something to be aware of. A GAL also has the ability, they may recommend a settlement to their ward, but they cannot they can't approve one and they can't refuse one. Dinah actually worked on a case that is pretty seminal to this idea, where a GAL essentially agreed to have their ward vacate their SRO for a very small amount of money. And Dinah was able to, I'm going to toot her horn for her. Dinah was able to get that settlement vacated, got a new GAL for this person, and ultimately allowed this person to keep their home. So I think that's another really important thing to think about, right? Like we often think about guardians as like stepping into the shoes of the people that they're meant to protect. And sometimes they don't always act in the best interests of their ward. So, there are judges that are great at allocating stipulations and really making sure that people understand them. And there are judges that maybe aren't as good and see that a GAL has signed off on it and say they don't do any sort of like investigative work of their own to figure out whether or not the person that is supposed to be protected in this situation has agreed to what their GAL has agreed to. They can also, as far as a settlement offer, they can review and recommend it to the court in the same way that they can like review and recommend to their ward. Yeah, but that's only if so that's like sort of interacts with Article 81, right? Like that's only if they're a juvenile who really can't be sued in housing court, or if they're judicially declared incompetent, meaning that they've gotten an Article 81 guardian. So like Adriana just asked, what happens if the guardian ad litem and the ward disagree? And that's always difficult, right? It's sometimes easier when there's a lawyer involved or another advocate, a social worker. And so there's like it's really divided. The courts are very divided because there's no sort of guidance in the law about what happens if a ward disagrees with what their guardian ad litem suggests that they do. Some courts take the position that a guardian ad litem can take the wishes into account, but that their sort of judgment should prevail. Again, the case that Dinah worked on stands for pretty much the exact opposite, the exact opposite of that, right? Like, that they cannot agree to something like vacating an apartment, giving up an apartment. Like it's such a huge thing to give up. So go ahead, Dinah.
Yeah. So I think that, I don't know how many of you have been doing this for a while. I have. So I think there has been more of a shift in the last few years towards more judges accepting that GALs can't settle cases because of the decision that Meg was talking about. I have not seen as much pushback from judges about that. But it may vary depending on it'll vary depending on the judge and even the boroughs sometimes. But a GAL, as we said, they're appointed without a hearing, and they're appointed without any sort of expert finding. And so, the idea that this person who's just appointed, sometimes just by a judge because they see a person in their courtroom that they think needs help, the idea that that person could then surrender an apartment is pretty appalling, honestly. There's no protections there to make sure the person's rights are protected. There's nothing to make sure the person actually needs a GAL. There's nothing to make sure the person, if they do need a GAL, that they need help making decisions on whether to continue living in their apartment. GALs sometimes are appointed just because the person needs help with one shot or because the person needs help, getting a heavy duty cleaning. And so to get from that to surrendering an apartment is really problematic.
Yeah, and I think that there are often, and I guess I see less of this now, but there are instances in which judges appoint guardians ad litem simply because they don't want to deal with a difficult person, right? Like they may not be incapable of defending themselves in housing court, and maybe the way that they present to the judge is hyper capable of defending themselves, and the judge simply thinks that it's easier to deal with one that they deal with all the time, which is obviously abuse of the system, right? But that is something I think that lawyers get referrals all the time for the same reason, right? It's easier to deal with someone who knows the system and works within it for a judge who may not want to do their job. I'm just looking at the questions in the chat right now. Qualification. What? Go ahead.
Sorry, I just wanted to answer Adriana's question.
Go ahead. Yeah.
How does it work if there's a GAL and a lawyer and they disagree with each other? Who takes point? The lawyer. For a lot of the reasons that we've described, is like, I've been retained by the person. I represent the person's interests. The person tells me what to do. They are my client. The GAL is not my client. And the GAL does not have the authority to make decisions for my client. If there's if there's a disagreement between the GAL and the lawyer, and the client may not have capacity. I feel like we're referring a lot to a future part of the training, the Article 81 part, but it is, they interact a lot. And I think the contrast between the two of them helps illustrate sort of the limitations of the GAL. But one of the things that comes up sometimes is if you have a client who truly lacks capacity to make decisions, and truly lacks capacity to sort of conduct activities of daily living, then the issue, a lot of judges want to say, well, who can settle this case? And the answer to that question is no one. The answer to that question is that someone needs to move for an Article 81 guardian. And judges don't necessarily want to hear that. They want someone who can settle the case, who can resolve the case. So that's my answer to Adriana's question.
Yeah.
Want to take NH's?
Yeah. So as far as qualifications to be a JL, it's like a training course that you can take through the court system. I think you have to pay some small amount of money and then you register with the court system. As far as GALs, like, are they supposed to, another question is, are GALs supposed to assist in escorting and helping to apply for rental assistance? I mean, my position is that, like, yeah, they are. It's part of their, I guess, actually, let me step back a second. When they're appointed, sometimes the order appointing them tells us the scope of what they're supposed to be doing, right? And so the order could be very general, just saying like they're supposed to help with this case, like help with this housing court case, right? Helping with this housing court case often means helping gather documents for a one-shot deal, helping going on like Access HRA or going to a job center to apply for a one-shot deal, working with the city FEPS community-based organization. Like there are a lot of things in a nuisance holdover, contacting APS to see if there's the ability to do a heavy duty cleaning, or seeing if the tenant that they're assisting has resources to do that themselves. Like I think that the scope of the things that they do, they're supposed to be protecting the best interests of the person that their ward, right? So yes, they should be doing that. Does it happen all the time? Not all the time, right? Like in a perfect world, everyone would have time to do all of these things, but that, I mean, I think that everyone here understands that we all have a giant, there's a housing crisis in New York City, there's an eviction crisis, and I think that every single person involved in the housing court is overwhelmed. So Dinah, do you want to take this question from Carolina? Sorry, I hope I said your name right.
Sure. So can you go over specific examples of when an attorney should include a GAL? I invite the GAL to every home visit or meeting with the client and give them updates on how those meetings went. The GALs seem to understand that their responsibility is just to appear in court on behalf of their wards. Does that make sense? Yes, that makes sense. I think that follows very well in the question about one-shots, which is that I think there are a lot of things GALs can and should be doing that they don't do. And I just, in full disclosure, like I said, I've been doing this is year 19. I just don't involve GALs very much anymore, because I find that it's more work for me to try to engage them. There are some GALs who, if one of those GALs is appointed in my case, I'm like, great, this person and I can work together and we'll talk about things, and they can do some stuff. But there are others where I just don't engage with them, and they don't engage with me. Like, it's not like I'm shunning them or something. There's a mutual disengagement, and so that means that I or my office have to do all the work, and I think we all would love it if GALs could do more one-shot advocacy or even APS advocacy, but like just to sound jaded, I quite frankly sometimes have found it more work to try to get a GAL to do those things than to just do it myself. But I don't, there have been GALs that have been just a joy to work with, but also just want to acknowledge that part of this is OCA's fault. I think they get paid $600 if it's an open APS case. And so, $600, like, I think anyone here who's tried to help someone get a one shot knows that, it takes a lot more than $600 worth of work. So the system is not set up well. They don't have the support they need to do this work.
And that's, I mean, and they only get paid if the person that they like, the ward is an APS client. Otherwise, they don't get paid at all, which is why so often the court wants you to make an APS referral and have an open APS case so that that HRA will pay this like meager, I think it's now $750. But that's still not a sufficient amount of money to do these cases, right?
And to stay on the list, to stay on the GAL list that gets referrals, they have to take some free cases. So they're being expected to work for free. And it's not really a volunteer job, like a lot of people volunteer to do stuff, and but most GALs are they need to get paid. So there's a lot of issues there with how the program is administered. And I'm sorry, my cat is screaming at me.
Okay. All right. I don't believe there's a specific office for GALs. I know that they work with HRA's Office of Legal Affairs. I imagine that's the most official office. They don't they're mostly sort of independent folks who do this. Let's see, how long is a GAL on a typical case? Usually, unless they're removed, which is something we'll get into a little bit later, from the moment they are appointed until the end. So it could be a very long time, it could be a short time, depends on how the case resolves. Are there any instances where a GAL can also represent the tenant as a housing court as their attorney? No, I don't know. There are a lot of GALs who are not attorneys at all. You don't need to be an attorney to be a GAL. And I think that I think that they're sort of counterintuitive to one another, right? An attorney is guided by their client. And a GAL is yeah, I don't think that Dinah, I don't know, Dinah, if you want to jump in, but I don't think that there's an instance where that is, especially if you're an attorney, that's ethical to do.
Yeah, I think the fact that GALs are expected to make reports to the court means that they can't represent the person, because that would require breaching attorney-client privilege. So yeah, I don't think those two are compatible.
Yeah. Which actually is a great little segue to our next. Oh, the GAL is paid one time at the end of the case. So $750 one time for as little or as much work as they do. Yeah. Oh, wow, it's gone up a lot. Still not enough, but $10.50. We should update our materials. I'll make a note of that. Okay. Landlord's attorneys as GALs. That seems like a breach of an ethical. I know who you're talking about. At least one person I know who you're talking about. I feel like that's wild. Far be it for me to pass judgment on anyone, but that seems wildly unethical. But there are firms who represent tenants and landlords, so I guess it's not that different. Okay, so I'm gonna move on to court oversight of guardians ad litem. So like Dinah just said, guardians ad litem are expected to make reports to the court, and in turn, courts have continuing obligation to supervise guardians ad litem their work. So in extreme cases, that may be vacating a stipulation of settlement, like in Dinah's case, where the GAL just like didn't do what they're like legally obligated to do. And for more routine cases, a judge will make sure that, let's say, they've met with their ward, they've made a home visit, they've determined what their ward desires as an outcome of the case, investigated and weighed all the factors in the case to recommend a settlement that's in the best interest of the ward, and has also taken into account their desires, developed a plan to assist with obtaining repairs or a one-shot deal or ongoing assistance like FEPS or city FEPS, taken the steps to follow through with those plans. And then also in situations that are not uncommon, like making sure that they know where their ward is, right? Are they coming to court? Have they been meeting with them? If they're not meeting with them, what steps have they taken to find them? And then, of course, you know, where a stipulation has like been recommended by a GAL, there is an advisory notice that requires the judge to allocute that stipulation, as if the GAL were like a non-attorney, as if they were a pro se litigant. So that means allocuting it at open court, asking questions. Like I said earlier, some judges are way better at this than other judges, just generally allocuting stipulations. We've gone through the compensation portion. So I guess we'll talk now about removal of a GAL. So what happens when they're not doing any of the things that we've been talking about, or they're not acting in the best interest of the ward? What if their conduct like harms or prejudices the person? I can think of a few situations in which, you know, let's take a clutter nuisance, for example, where the GAL has like actively disclosed to the landlord that the situation is getting worse, right? Does that serve the best interest of their ward? No, because it's more likely that it will lead to their ward's eviction. So anyone can move for a GAL to be removed, in the same way that anyone can move for a GAL to be appointed. The court can do it sua sponte. I've seen that happen a few times where it's just been very obvious that the GAL has been doing almost nothing to assist their ward. Sometimes not even coming to court. Nothing will make the court remove a GAL faster than the GAL just not showing up. If they, ignore their ward's wishes, if they fail to secure funds for like a one-shot deal, if they agree to some, I think that like in a lot of stipulations where it's very obvious that they did not consider their ward's interests, right? Like if there's a stip that requires not only payment by a date that is outside of the realm of possibility, given the delays with HRA and all of the other community-based organizations and OTDA, or with an acceleration clause saying if they don't pay their December rent and it's November 30th, and they agree that if they don't pay their December rent by the 5th, that they can be evicted immediately. Like that's no one should be agreeing to that. Let alone someone who has been appointed to protect the interests of somebody else. So sometimes, I'm just answering Adriana's question in the chat. If the court removes a GAL, would there automatically be one to fill their spot? Sometimes. It really depends. Like I think, I've made a few motions to have GALs relieved, and I've always asked that another one be appointed, only because I knew that my client still needed a GAL. They just and in fact, they needed it more because the person who had been appointed was just simply not doing anything, right? And also like if like Dinah said earlier, people's sort of capabilities really fluctuate, especially if they have mental health issues. And so perhaps your client needed a GAL before and no longer does. Maybe some other stressor has been removed from their life so they can actively participate in the litigation. Then like the need for a GAL has mooted itself out. And then you have an obligation to your client to say, this is no longer necessary. Okay. A GAL can be on more than one case, and in fact, most GALs have a giant docket of cases, mostly because of the compensation issue that we talked about earlier. Have you found that staff at HRA are open to working with GALs on the one-shot deal? I don't know. Dinah, do you have any insight into that?
I don't. I suspect no, but I don't know.
Yeah, I imagine they have the same contempt for GALs that they have for every other member of the public that they interact with. All right, Carolina. As attorneys, we are guided to never do anything contrary to the client's wishes. What should attorneys do when we learn of conflicts? As an example, if a GAL is asking APS for services that the client has said that they do not want, should we say something? Apparently, APS has changed their protocols and will only submit a one-shot deal application on behalf of a tenant if they go through the APS psych evaluation and are deemed to need financial management services, which then removes the person's autonomy. Even if I agree that the person could benefit from certain services, as an attorney, I am ethically prohibited from saying that. Are GALs subject to the similar ethical duties, or am I extrapolating the professional rules? Dinah? Lucy?
GALs are not subject to similar ethical duties. And I think there's an argument, they're supposed to act in the best interest of their ward. And so I think if a GAL thinks someone needs financial management, I think it's appropriate for them to advocate for that. I think that, they can't force that on someone because they don't have a full guardianship powers. And, the tenant can just refuse to cooperate and thwart that process. And then as far as your role, I think it really depends on, the rule of ethics 1.14, which says you can take protective action, if your client is at serious risk of harm, unless that action is taken. I do think that opens the door for you to advocate for certain things that your client doesn't want, but I think it's something you should avoid doing unless you feel like it really, like if the option is between your client getting evicted and you trying to help them get on financial management, then I think the decision weighs in the favor of financial management. But sometimes you can also resolve that problem, especially if you have like a social work department, by helping the person set up automatic bill pay. My office has had clients who never had a bank account. So we have social work interns who can go to the bank with them, help them open a bank account, help them set up automatic bill pay. So if there are ways around financial management or something like that, those are worth exploring. I don't know did that answer your question? Okay.
The HIPAA question? Go ahead.
Oh, I was just going to read the next. If a GAL is supposed to help a ward get a voucher for a one-shot deal, does HRA Homebase recognize this in terms of HIPAA confidential information? I think they would have to sign. They would have to sign a release. Not necessarily a HIPAA if it's for a one-shot, but like a general release authorizing information to be released. Does that make sense?
Yeah.
Okay. Can the client remove the GAL if they don't want one, even if it's the judge who ordered it? They could try. I think they would have a difficult road ahead of them, but anyone can make a motion to remove a GAL, and I think a pro se tenant would be challenging for them to do that, but they certainly can. They can try. So yes, a client can ask for that, but it's up to the judge to approve it.
Are there any other questions before we move on? Okay. Now we're going to talk about the Article 81 of the mental hygiene law.
Yes. So Article 81 guardians are surrogate decision makers. So Meg said earlier that some people talk about GALs as someone who steps in the shoes of their ward. And that is a common misconception and used to be a very common misconception, less common now. But an Article 81 guardian does essentially step into the shoes of their ward. They are a surrogate decision maker. And so that means if just to jump ahead a little to one of the important differences is an Article 81 guardian can surrender an apartment. They can make decisions about where a person will live, although Meg can probably correct me if I'm wrong. I think they have to ask the Article 81 judge for permission if they want to relocate someone. Yes. Okay.
Yeah.
So an Article 81 guardian is a significant deprivation of liberty. So the procedures to get one are massively different. And so this section is going to go into that a little bit and how that affects, the difference between the two types of guardian. So just some terminology. When someone brings an Article 81 guardianship proceeding before the case has been decided, the person that's the subject of that proceeding is called the person alleged to be incapacitated, so commonly shortened as AIP, the alleged incapacitated person. So if you have a client or someone you're working with who is the subject of an Article 81 proceeding that has not been gotten to a decision yet, they'll be referred to as the AIP. And least restrictive form of intervention, we talked about that a little bit. It's a concept in disability law that you should do the least restrictive thing for a person. And so how that works with Article 81 is that, if someone needs an Article 81 guardian to declutter their apartment, that doesn't necessarily mean they need an Article 81 for every single thing in their life. And so like I had a client who refused to consent to a heavy duty cleaning, refused to consent to any attempt to declutter his apartment. And so he did get an Article 81 guardian, but it was just for the purpose of decluttering his apartment. He still had control over his money and his healthcare decisions. So that is how least restrictive form of intervention can work even when someone has an Article 81 guardian. So under Article 81, the court, and it's a Supreme Court, it's not housing court, it's not civil court, can appoint a guardian if the court determines that the appointment is necessary to provide for the personal needs of that person, including food, clothing, shelter, healthcare, or safety, and or to manage the property and financial affairs of that person. And that the person agrees to the appointment or that the person is incapacitated. And so the determination of incapacity has to be based on clear and convincing evidence. The court has to determine that the person is likely to suffer harm because, one, the person is unable to provide for personal needs and or property management, and the person cannot adequately understand and appreciate the nature and consequences of such inability. So this is a functional assessment. It's not about like what diagnosis do you have, what symptoms do you have. It's like, what can you do? So can you manage your personal needs? Can you manage your finances? Can you manage your healthcare decisions? Can you manage your activities of daily living, which includes, you know, self-care, housekeeping, money management, grooming? And is the person able to understand the nature and consequences of their inability to manage those things? So does the person understand that if they don't do certain things, other bad things are going to happen? And I think that's, yeah, so that's it. And the court has to, well, Megan's going to talk about the procedure. So that's it for the intro.
And I'll just say that I think it really depends on the mayor and the who's in power. During the de Blasio administration, there was a real push for Article 81s to prevent homelessness. Whether or not that worked, I don't know. And so I think there's like a real ebb and flow when it comes to the administration's sort of whether they think of this as like a tool or like a remedy. So the procedure for appointing an Article 81 guardian, it's always brought by order to show cause in Supreme Court. For our purposes, since we're mostly, I assume that we're mostly like tenant advocates here. If there is an outstanding eviction case, it will often be brought with as an order to show cause with a temporary restraining order, meaning that whoever let me just take a step back for a second. Anyone, in the same way that anyone can petition for a GL to be appointed, anyone can petition for an Article 81 guardian to be appointed. As Dinah said, the standard is a lot higher. There's more procedure there, so it may not be as successful if just sort of like the landlord's attorney is moving for it. Often it's a family member or APS that moves for an Article 81 guardian. And so in the order to show cause, it can be brought, like I said, with a temporary restraining order, often in sort of like in cases that are relevant to our practice, to stay any housing court proceeding until a guardian has been appointed. So it can certainly be beneficial to tenant advocates because it puts your housing court case on pause for sometimes an indefinite period of time. It also sometimes gives you a little bit more resources to be working with. But yeah, so that's a great sort of provisional remedy that housing advocates should be aware of, the temporary restraining order. So also as another provisional remedy, there may be a temporary guardian appointed to maybe help apply for a one-shot deal or get someone's finances in order. It's a limited order that requires at least some showing of emergency. And that is those are temporary powers given to someone to sort of like prevent any waste or harm that comes to the AIP before the court can hold their full proceeding on the merits. The petitions for Article 81 guardians are very, very like standard, sort of often they'll lay out what activities of daily living that the AIP cannot engage in and how that will harm them. Because as Dinah said, it's the petition for an Article 81 guardian is like a pretty significant impingement on someone's liberty. They are entitled to an attorney. The court appoints an attorney. Often it's mental hygiene legal services, which operate in all of the they operate statewide, and they are appointed as counsel to the AIP to act in their best interest. sorry, yes, an AIP is an alleged incapacitated person. That's sort of what the respondent in an Article 81 guardianship is commonly referred to. They're alleged to be incapacitated. And then of course the hearing is to find out whether or not they are in fact an incapacitated person. A temporary guardian, again, they have to have the most limited powers to assist, so, they're not going to get a full list of things that they can do. It's more of what specific powers they need in this instance to prevent harm coming to the AIP. A court evaluator is also appointed, and they sort of act as like the eyes and ears of the court. They are required to make a report to the court. They're required to interview the AIP and sort of anyone else involved in their case to determine whether or not this is necessary. There's a hearing. The hearings are often, they are open hearings, but on a showing of good cause, which often means very little. They can be closed to the public. Often this is done to prevent a landlord's attorney or a landlord themselves from hearing what goes on in the hearing, right? Like if the allegations are that this person can't take care of their personal hygiene or their resources, you don't want a landlord or their attorney in their hearing, like essentially writing everything down for their petition in housing court. So often frankly, anyone can ask the court to close off the hearing. And I think it's pretty standard practice that the court will close it off to at least the landlord's attorney. Once a hearing has been concluded, whether the court finds the person to be incapacitated, meaning that they cannot consent to the appointment of a guardian, or if they're a person in need of a guardian. Sorry, I just totally lost my train of thought. Friday afternoon, right? 4:15. If they're a PING or if they're an IP, an incapacitated person or a person in need of a guardian, the court still has to narrow down the powers of the permanent guardian to make sure it's the least restrictive means to serve this person, right? Like Dinah talked about her client who just needed someone to get in there and do a heavy duty cleaning. Sometimes it's as simple as, marshaling people's assets to set up a monthly payment to the landlord for their rent, and then depositing everything else into another account that their IP or PING has access to. I'm not going to get into a ton of this because it's not like totally relevant. But once a guardian has been appointed, often we as tenant advocates sort of step away, right? The guardian will often, especially if there's a pending landlord-tenant case, have the power to deal with that. A lot of the community guardians, in fact, all of the community guardians in New York City have like in-house counsel. There was a judge who worked in the guardianship part for a very long time, who would often require legal services providers to stay on as attorneys. I don't know how well that worked. But it was nice because often, we as legal service providers have formed a relationship with our clients, and to sort of take a steady presence in their life away is maybe not the best thing to do. And this judge did recognize that. And that was really wonderful. I don't know that happens anymore. Once there's a hearing, also the temporary restraining order on the housing court matter will often expire, meaning like it will expire after 30 days of entry of the order appointing the guardian, 60 days. So it's not a finite, it's a finite amount of time that the housing court case is sort of stayed. Yeah. The Article 81 guardian from a list like the GLs, or is it a family member? It can be, yes. There are community-based organizations, self-help community services. This may not be the most up-to-date one. I don't actually know. Self-help, JASA, and New York Community Guardian Services were the ones like 7 years ago that were the ones that HRA worked with. I imagine they have different ones or newer ones. Those are like contracted organizations that are paid by HRA per case. And they have like a whole team of social workers and stuff. Often, because like GLs often, or GLs, God, sorry, guardians, Article 81 guardians have to make really substantive annual reports to the court, including like financial reports, all sorts of reports on what they've done for the person that over whom they have the guardianship, that it's not often not possible for like a layperson to do it unless they have the resources to hire an accountant or hire someone else to do this. There are also situations where the guardian is split, and so you can have a personal needs guardian who takes care of, let's say, someone's like they can get home care services, so someone can effectively deal with their hygiene, they can shop and cook and do all these things for their family. It's often a family member. And then there can be a financial personal needs and the property management guardian, who sometimes is like an accountant or a bank or one of these community guardian organizations that have experience dealing with like the finances. So you can split roles too, but that's like something that we don't really deal with in housing court as housing court advocates. Any questions about Article 80? Any other questions about Article 81 guardians? This is an interesting anecdote from Vivian, who once worked with a tenant who was temporarily incapacitated due to effects of prescription medicine. When the medication was changed, she regained her capacity but was unable to have the guardianship terminated. Although she won her housing court case, thanks to her attorneys, the guardianship continued. That is something that often happens, right? Especially if someone has been adjudicated to be incompetent, right? Like, or incapacitated. There's this idea that because they've been adjudicated this way, that they sort of stay that way. And obviously, given this, that's not accurate. It's very difficult for someone to get an Article 81 guardian removed as compared to a guardian ad litem.
I think so. One thing, since it's only 4:21, and I just realized that we don't really talk about this, is how you as a housing attorney or advocate get from the point where you have a client who has a GAL and you don't think a GAL is enough and you think the person needs an Article 81 guardian. What do you do? Some legal services organizations will bring the Article 81 guardian themselves, but I think most don't, in which case the only real option if your client doesn't have resources is to refer to APS, Adult Protective Services, which then has to go through their whole process and make the determination that the person needs an Article 81 guardian, and then refer it to the Office of Legal Affairs, OLA, and then they review it too. And so if you end up in a situation where you have a client or someone you're working with who might need an Article 81 guardian, it can be a very, very long process to try to get that to happen. And one of the things that happens very frequently is the Office of Legal Affairs will come in very late in the case. And so you'll see cases where there's actually been a trial and the person has lost the trial. And then OLA will bring the guardianship case. And then there's the stay that Meg talked about. And so you're in a position where your client is just like this far from being evicted. And then they come in and get the stay. And the stay can last months, like a year or more. Because it's a very slow process. And so that can be a very frustrating part of the system to try to navigate. And of course, you're trying to keep your client housed while you're sort of hoping this other agency that you don't have control over is going to do what you think they need to do. So that's the position you find yourself in sometimes when you're advocating for someone in housing court who may lack capacity.
There's a question in the chat. Is there any differences between when an eviction takes place with a case that has a GL versus one that doesn't? Like, is the city required to find temporary housing for the tenant at that point because it was a GL involved case? Outside of like the New York City right to shelter, no, there's no difference. No, doesn't matter if they had a GL or frankly, like even if they had an Article 81 guardian, if they're evicted, there are different people who are responsible for that person, but city is not required to find anyone housing outside of the shelter system.
Yeah, the most the judge might do is order the marshal to notify APS before an eviction, and then APS will come check out the person and then a lot of times do nothing. But that is sort of like the very last gasp before a person's evicted. If there's a GAL, that might happen. Any other questions? That's it. That's all of our presentation.
So these are just some resources. Both CUNY School of Law and Cardozo School of Law have elder law clinics that help with stuff like this. CUNY has a whole like guide to becoming an Article 81 guardian for a family member and doing it without a lawyer, which is really helpful, especially if APS won't get involved and you have family involved that that is willing to take this pretty immense task on. If they file it, they can often judges will make APS come in, OLA come in, and if they find that the person does need a guardian but doesn't, the family can't necessarily do it. This next slide we're gonna skip. We were gonna do a hypo, but then we realized it was like very lawyer focused. So, any questions, comments? I'm gonna stop screen sharing.
We have about one more question in the chat about if a judge can order the GAL to do something. Like if the tenant complains about something, can a judge order a GAL to do something?
I mean, a judge could order anyone to do anything, right? Like, yeah, I mean, they could.
I think she's saying in the context of like, if the like we talked about earlier, if the GAL is not being helpful, can the judge order the GAL to be more helpful or?
I mean, they could, but like, so the risk of defying a judge's order is being held in contempt. And I don't know that there are judges that would like risk because there's such a limited pool of GALs and like the need for them. I don't necessarily think that a judge would necessarily want to be put in a position where they may have to find them in contempt. And then I mean, this is just all very hypothetical. I don't know. I've never seen it happen. I don't know if Dinah, you wanna?
Yeah, I mean, judges will tell GALs to do things. And then I think if the GAL doesn't do it, the main thing that the judge does is get angry, you know, and scold them. And, you know, I've been scolded by a judge and I tend to then do what the judge says. But like Meg said, you know, if somebody doesn't, then then what? And since there is a limited pool of GALs, you know, there's the list, and so you deal with the same GALs over and over and over again. It's like anything in housing court, you deal with the same landlord's attorneys, the same judges, the same. So everybody kind of knows each other. And so even if you don't think of these people as people you work with, like I don't work with landlord's attorneys, but there is this, you know, this culture that you know each other. And so I think sometimes judges don't come down hard on GALs because they might have that same GAL in like 20 other cases. And also the judges know the GALs are getting paid, I guess, $1,050. And so I think judges don't want to come down too hard on GALs who are doing kind of a thankless task for very little money. So I think it's possible the judges are more forceful with pro se tenants. Like my experience is all, you know, cases where I was involved. And so I think judges also, if there's a tenant's attorney involved, they're probably thinking, well, the tenant's attorney will take care of this.
All right. I think we had someone share a link in the chat from the court's website, nycourts.gov, talking about the GAL program. Any other questions anybody had? All right. If there are no more questions, I just want to thank you both for coming to give us this wonderful, wonderful training, very informative. As I think you could see, everyone really enjoyed it, was very interested. Thank you to everyone who showed up and participated. We do have 2 more upcoming trainings. We have one on Monday on tenants' rights and supportive housing, and then we have another one on Wednesday on the overview of SCREE and DREE. So if anyone is interested in attaining those, they can sign up to attend on our website. But again, thank you all for attending. Thank you both for our presentation, and everyone have a wonderful, wonderful night.
Enjoy your weekend, everyone.
Thank you, guys. We also do have our website that was just shared in the chat. So for anyone who wants to sign up for that, can sign up via that link. And our hotline phone number was also posted in the chat. All right. Thank you all. You guys have a great night.